Good afternoon. My name is Sarah Soto, and I will be moderating our panel today regarding navigating the Age Discrimination and Employment Act in light of America's ever older workforce. I am a principal in Bressler's Florida office, and I'm happy to be joined today by our presenters, all of whom are experienced practitioners. And let me introduce them briefly to you. First, Lauren Fenton Valdivia. As you can see, Lauren's a principal she's based in Florida, but she works out of several of our offices. Matthew Penfield is a principal out of our Alabama office. Joelle Sims is a principal. She's based in Texas, but she also works out of our Florida office. And Emily Bordens is counsel, and she works out of New Jersey and New York. So today's discussion is going to deal with issues in the area of hiring and recruiting, dealing with existing employees, termination, and we'll sprinkle some recent ADEA cases into the discussion. As I'm sure all of you know, the ADEA's protections extend to all aspects of all terms and conditions of employment, including but not limited to, of course, hiring, firing, paying, job assignments, promotions, layoffs, et cetera, et cetera, et cetera. And therefore, we're going to try to cover its applications to several of these areas during our presentation. And since we have a lot to cover, let's begin by having Matthew join us and begin discussing the recruitment process, please.
Great. Thank you, Sarah. As Sarah mentioned, we want to cover a lot of material. We might have bitten off a little more than we needed to for today, hiring and recruiting, existing and termination, but we want to give you a broad overview of how some best practices and what to be aware of. And as you have specific issues that come up, we're always here to reach out to. On the slide, it tells you the EEOC's guidance is very clear. The protection extends to recruitment and hiring, or as it says, the law prohibits discrimination in any aspect of employment, including hiring, firing, pay, job assignments, promotions, layoff, and the like. The scope of the protections under the Age Discrimination and Employment Act is very broad. And in fact, it begins prior to those formal application documents and interviews that we're even going to talk about. The EEOC states that the protection extends even as far as the process that the employer begins or engages in to attract applicants. It is illegal for an employer to publish a job advertisement that shows a preference for or discourages someone from applying for a job because of his or her age. And in fact, in its guidance, the EEOC goes as far as stating this, that a help wanted ad that states, seeking recent college graduates may discourage people over 40 from applying, and therefore it may violate the law. So we're not going to get into some of those earlier job placement decisions. We're going to start at the application stage and talk about application and hiring. So what should your application documents look like? It probably not that many years ago, and some of you likely remember that whenever you used to fill out a job applicant, it always had a place for give us your date of birth. Most of those have been removed by now. And I did want to say, if yours have not, don't share that in the chat. Don't raise your hand and say it. Contact us afterwards and we'll see what we can do to help you out. We'll help you out with that. But more than just looking for age, the applications and the guidance from the EEOC state, the application should focus on work experience and work-related questions. It should seek information about the types and the depth of experience as opposed to a number of years or with specific companies. In fact, the way we put it under the recruitment process is that it should really focus on qualifications. And if applications are asking about your qualifications, first, you need to make sure that those qualifications are actually required to perform the job. If someone doesn't need a specific degree, or a specific certification, then the application should not inquire about those things. They can get you in trouble down the road. When they are required, the application should ask whether the applicant has the qualifications, not when they were obtained or for how many years have you held this. Those questions go to age and they cause potential problems. Now, moving forward to the interview process, going from recruitment to interviewing.
Right, and one thing I'll just jump in on real quick,
Sure.
Matthew, to kind of to that point. I mean, some of these things, when we talk about them, they seem obvious, but it's important to keep in mind that some of these things seem more innocuous when they're in a job application. So similar to what Matthew said with a date of birth, historically, and maybe even now, it wouldn't be uncommon to see, where did you get your undergraduate degree? Where did you get that and what year? Where did you get your law degree, for example, and what year? And so, it's important to keep in mind that those questions, although they may be relevant to the particular position in terms of degree verification, which we'll get into in a little bit, in terms of post-offer inquiries, those could potentially get you in trouble if you're asking for the year of graduation, because those can be perceived as being age-related questions.
No, that's exactly right. You've got to think broader than just asking about the specific age, and you've got to look at your documents and think about what is it that we're asking and how could this be perceived by someone in the future, or how could it be perceived? I always ask this question: how could this be perceived by the EEOC if someone brings a complaint? Because that's who you're going to have to respond to. We have the same problems in interviewing, though. It's not just on the written page. The process has to be carefully planned. And we provided some bullet points here for you, having diversity training, age diverse hiring panel, asking the same questions. And it's because it's important that your interviewers know what can and can't be asked when they're sitting across the table, or in the last year and a half when they're sitting across the computer screen from someone, to ask whether you think, are there questions that violate the Age Discrimination Act? Yes, there are. And we're going to put some of those up in front of you. We're going to give you a polling question now, and we'd like for you to take the opportunity to respond to this. So you're sitting in an interview, and the candidate is across from you, and you say, "How old are you?" Does that violate the ADEA? And while those are kind of rolling in, I want to go back and talk a little bit about how interviewers should have diversity training. While you're getting a chance to kind of answer that question, as we see that rolling in, our best practice that we put out under this question is interviewers should have diversity training. Now, today, almost every workforce, almost every employer is offering diversity and inclusion training, oftentimes on an annual basis, and they have to certify that. It's important to remember that any interviewer needs to be not only included in that process, but if they are truly someone that is a gatekeeper, a frontline, a face of the company, then they need to have diversity training, and often specific training for those persons who are hiring managers, HR staff, those people who will be sitting across from candidates. Now, looking at our answers here, does the question violate the ADEA? How old are you? The overwhelming majority of people answered yes, absolutely. You just can't look at someone and say, "How old are you?" That's how we did on that question. Joelle, what are some of the other questions that might come up that are not as specific and direct, but might still be getting at this question that we need to be careful about?
Sure. So we just launched another poll. One question, and this is, I think, increasingly common in the digital age, and now that we're sort of venturing into Zoom and remote work and that sort of thing. Are you familiar with state-of-the-art technology? And we'll give everyone just a minute to answer. And this one, I think, is going to be interesting.
Yeah.
So as people are answering, and I don't want to shift anyone's true answer as we go through this, that is a grayer area, right? I think to be on the safer side, yes, that could violate the ADEA, because someone could perceive that as being more geared towards state-of-the-art technology, meaning that if you're older, they're trying to gauge how old you might be. If you are more adept at that, or not. And here, I'll end the poll here and share the results. So it looks like most of the audience thought that would not violate it. And so the question really is, look, any specific violation is going to be fact intensive, right? It's going to come down to that particular person, the facts, the circumstances, the questions, whether they were given the job or not given the job. But in terms of attempting to protect yourself and protect the company, what the better practice is not to ask, are you familiar with state-of-the-art technology, but to ask questions that are specific to the position and the role. So for instance, are you adept at using Zoom? Are you adept at using Excel? Are you adept at using, Workshare or Lotus or whatever specific technology is actually required for the job, as opposed to just sort of generally asking, are you familiar with state-of-the-art technology? Because that may convey to someone that you're trying to weed out people who may be of a certain age group.
Yeah, and Joel, I think that goes back to, go ahead.
Just to pitch in for a moment and point
Sure.
out the obvious. If you're going to ask, you should have a particular set of questions that you're going to ask in connection with the interview for any position. Those questions should not vary depending on who you're looking at during the interview, because of course that would definitely signal something.
Sarah, that's a great point, and it goes right to the third best practice that we list there under interviews should be carefully planned. Ask the same questions to all candidates. Of course, that doesn't mean that you're not going to have times when in the midst of the conversation and the discussion, that questioning and that conversation leads to different places. But you need to make sure that the same questions, at least the formal questions, are asked to each candidate. Because later, if someone says, these questions were asked of me, and I think that they were geared towards trying to hire a younger workforce, then you as the employer need to be able to say, that's actually not true. We carefully planned out our questions, we document them, and we ask them of everyone. And so that is a best practice that you need to have to avoid. Not saying you would avoid a lawsuit, but you definitely have a better defense in that lawsuit. So the other best practice before we move on to the next point here is to have an age diverse hiring panel. And I think every so often employers need to stop and they need to look at who is the panel here. Maybe it's the hiring panel, maybe it's the compensation panel, maybe it's the managers who are making promotion decisions, but who is this panel and are they diverse? And do they have not only the training, but as a whole, the diversity to be aware of the decisions that are at issue? So why is this important? Everybody says, yeah, I understand why we're doing this, but why is this important? Well, first, because you have to follow the law. It's that clean. Employers that fail to adhere to these best practices, though, they face lawsuits, they face investigations, and they face settlements. Seasons 52, we have on the screen, Seasons 52, which is a restaurant chain, had a settlement with the EEOC in 2018. Concerned applicants, here's what happened. Concerned applicants raised complaints to the EEOC, and those applicants believed that they were not hired precisely because of their age. And they relied on the fact that age-related comments were made to them during the interview process. Now, some of those comments are pretty easy to see. Most of the workers are younger. We're looking for workers who are fresh, thinking about code words that pop up. We're looking for workers who are fresh. Will you be comfortable here because most of our workforce is of younger people? Those practices ultimately resulted in a settlement with the EEOC that Seasons 52 paid $2.85 million to resolve those allegations. In fact, earlier this month, a lawsuit was filed against Eli Lilly and Company, the pharmaceutical company, and the plaintiffs there are seeking a class action based on what they allege are the company's hiring practices that violate the Age Discrimination Act. And specifically, the plaintiffs have alleged that the company has a strategy of attracting and hiring millennials and early career professionals to the exclusion of qualified older candidates. And in their complaint, they allege that the company favors those under 40 because the recruitment system requires applicants to either be affiliated with a university or part of the pharmaceutical company's internship program. We're not sure where that's going to go. Eli Lilly has not responded to or answered that complaint yet, but we're beginning to see again, more and more of these types of lawsuits where people are raising their hand and saying, I'm being disqualified based on my age. So one more thing that we want to discuss is how do we get the information we need from applicants? So we said at the beginning, watch out for your questions, watch out for the interviews. But what if there are specific things that you need to get from an applicant? And here, I think it's important to draw a line and a distinction between pre-offer questions and processes and post-offer questions and processes. And Joelle's going to share some of that with us now.
Sure. So when we made the comments earlier, some of you may be wondering, well, how, I need to verify that this person has a particular license or a particular degree in order to do the job. How am I supposed to do that if I don't know what year they graduated? And so the answer is, as Matthew said, is really drawing a line in the sand between pre-offer and post-offer. And so those things, to be safe and to protect the company should not be asked pre-offer. Once an offer has been extended, then you can request those things if they're necessary for the job. And, the reasoning there is that there has to be some reason that's not just checking what age this applicant or this person who's been offered a position is. And so, for instance, yes, absolutely. After you make an offer, you can, ask for information. And frankly, in a lot of industries, they do, specifically in the financial services industry, you've got to undergo pretty significant background checks, which includes verification of employment. Similar things with law firms. Oftentimes you'll want to verify that someone in fact got the law degree that they say they got, that they got their LLM degree that they say they got. And so I think if you save those questions and those inquiries until after an offer has been made, you're going to be in a much better position, because obviously if an offer has been made, they're not going to say, you didn't give me this job because of my age. Now, the other question that can come up in this context is if an offer is rescinded. And there are circumstances where offers are rescinded. A background check comes back different than what the person represented. They don't have the particular licensing or degree, or any variety of reasons. And I think the important takeaway from that, as you'll probably hear repeatedly during this webinar, is to, number one, make sure you document, right, the reasons why. And number two, make sure that the reasons why are not age-based, that it's because this information on a resume is false, or because the background check came back and it does not satisfy the requirements in order to hire for this position. And so if you can have a documented reason as other than age, then that's going to put you in a much better position if you're the subject of a lawsuit.
Thanks, Joelle.
All right.
We need to probably move on. We've spent some time on hiring and recruitment. Let's think about existing employees, and let's move towards that with a little bit of time we have left here with our section.
Well, let's do that. But let me ask you a question, because I think that the ADEA prohibitions sometimes are not as well understood by employers as other protected class of prohibitions. I've heard employers say, okay, so I'm going to spend X millions of dollars setting up a new department. I need leadership for this department. There's going to be a lot of training, etc. I want the people that are going to be involved in this department to be people who are likely to hang around with the company for 10 years or so. And therefore, I think that I need a younger group of people rather than an older group of people. I think it's pretty safe for me to say that that would be completely inappropriate, right?
Yes, Sarah, you are right about that. Although it may make sense economically for a company to think about, what is the long-term gain we're going to have from an employee in the seat. It was interesting. I was actually talking to another one of our partners this morning about this. The EEOC used to have a carve-out for apprenticeships programs. They would talk about those types of programs have a carve-out, and they're exempted from discrimination because they knew that you had to hire someone at a certain young age in order for them to progress and move their way through the process. Well, those aren't even exempted anymore. And so if those aren't exempted, even more so, just a general plan of, if I'm going to spend money to bring in an employee, I want to bring in a young employee so that I get the years of service. Those are going to be problematic. And it's going to be very easy in those cases, most likely for the person who didn't get the job, if they're 40 or older, to show that they didn't get the job specifically because of their age. I think that's a real concern, Sarah, and that's a great point. Yeah, that moves us into what we do with our existing employees. We know, and as you move on to this, we know a lot of you who are watching this today and with us today, you live in this world, you live in the HR world and deal with these statutes. There are things you just can't do with existing employees. You still have to be aware of actions that could lead to age claims, and we listed a few of those. Forms of harassment, promotions, compensation, and issues that arise with crafting succession plans with the company. Harassment claims can be made by anyone, and that's always important to remember. That can be a supervisor, but it can also be a coworker or a client or a customer, and they have to be so severe and frequent that it creates a hostile environment. However, I will tell you that when cases come into us and we look at them, what we might think is the threshold of what is severe and what is frequent, it's not what the employee thinks was severe or frequent. And what you want to do is take actions to avoid those complaints and those claims even coming in the door. Joelle and I were even talking about this briefly yesterday. You may recall a couple of years ago what hit the memes and the news, everything else is, can you say, okay, boomer at work? Is that harassing or is it not harassing? And does that cross the line? It made us think about multi-generational workforces. Joelle, what do you think about that?
Yeah, I think that's an important point, and also kind of to Sarah's point that, while there's things that we, would never do or never think of doing with respect to other protected classes, I think this specific class sometimes doesn't get the same attention. And so, one issue Matthew and I were talking about is exactly that. I mean, typically when you think of harassment, you think of coworkers, or a superior harassing a subordinate. But in this instance, I think you have to, it's not a one size fits all, right? You have to think could be instances where a subordinate is harassing a superior, right? Making jokes or comments, okay, boomer, or about the person's age, or, when you were in law school, did you have to transcribe your exams on, original papyrus paper, right? Or, comments to that effect. And that, may be joking around, but may, rise to the level, like Matthew said, that what we would perceive as being severe and persistent may be different for the workforce. And so I think it's important to keep an open mind, and especially when you're doing training on this and that sort of thing, to pay attention to the fact that this harassment may flow in ways differently than what we typically see or typically believe it might. And the other issue too, highlighting the bottom one there, is escalating concerns regarding diminished capacity. So this is a big issue, particularly in financial services, and really in any service-based profession, law firms as well. And the primary concern here is, are the customers or clients being protected? Are duties that are, that need to be fulfilled to them being fulfilled in an adequate way? And so when you're dealing with that, I think the key is to, like everything else, make sure you have something in writing that is not specific to age. So when you're dealing with diminished capacity, we often think that's due to age, right? And in some instances it may be, but it could also be someone who has a substance abuse problem. It could be someone who has side effects from medication. And so I think when you're dealing with that, there needs to be a specific plan, preferably written, in place that is age neutral, and that provides the same guidance and training to everyone for spotting these types of red flags and for investigating and dealing with them.
Joel, that's a great point. I want to go back and highlight one question that came in, and then move us on to the next phase, which is reductions in force implementation, some of the termination decisions. But someone asked, and I want to remind you that y'all can click on the question on your own screens and ask these questions. Someone asked, one can find someone's age in so many public places and sources of information. So wouldn't a defense simply be, well, if I wanted to discriminate based on age, I don't have to ask any of those questions during the hiring process? Well, surely you can make that defense, but you don't want to be in the position where you have to make that defense, because then the question is going to be, well, even if you could find it, then why are you specifically asking it? I mean, so it's a better practice just to avoid entering into any of those situations where you could be perceived as trying to gain information about someone's age so that you don't have to try to then come up with an excuse or a defense down the road. We're available to answer more questions, both in the questions box and then offline once we finish, but we're going to go ahead and shift this over to Emily, who's going to talk a little bit about what happens at the end of the employment cycle for employees.
Hi, everybody. We're going to move the slides over a little bit. Okay, great. So thank you guys so much for coming today. We are going to be talking now about reductions in force. And we're going to launch a polling question. Let's see if I can do this. Okay, so how many of you have been involved in conducting or planning a reduction in force? Getting some interesting responses. Okay, give you guys a couple more minutes. Okay.
And while we're doing that, let me provide you with the first CLE code for the seminar, which will be younger.
Okay, so we are now sharing the results with you, and it looks like we have a pretty even split here. So that's pretty interesting. So for the purposes of today, obviously, you know, we could talk for days about how to implement a reduction in force, but what we want to do today is give you some of the kind of high level, more interesting aspects of things for you to look out for. And obviously, if you are considering implementing a reduction in force or a reorganization, we would definitely encourage you to reach out to legal counsel to help, you know, go through these steps with you to try to help navigate any potential pitfalls.
So let me interject really quickly, Emily. So I guess since we have a sort of even split as to those who are familiar with reductions in forces and those who are not, maybe we could give sort of a basic explanation and then talk about alternatives to reductions in force.
Oh, that's great, Lauren. Thank you. So a reduction in force or reorganization is when an employer decides to cut or eliminate positions from their workforce. It could be as easy as, you know, we want to outsource a specific department. It could be, you know, a change in leadership and a complete reorganization of the entire company. It could be closing an office, something like that. It basically, a reduction in force or reorganization is any time that a company decides to eliminate someone's position or discharge someone from employment, typically for no fault of their own, you know, specifically, you know, reasons for discharge in these types of situation is, you know, due to the reorganization, but we're going to jump into that further. But before a company decides to take kind of a drastic route like this, one of the first things I'm going to ask a client is there an alternative to a reduction in force or a large scale layoff? You know, perhaps you could implement a hiring freeze or limit overtime, or maybe, you know, a company wants to rely on natural attrition. Sometimes I've had clients who have looked at their organizational chart, looked at their company chart and thought, well, I have an open position here. I want to eliminate someone from there. So maybe this candidate, this employee who, you know, we could transfer this employee and kind of kill two birds with one stone. Some employers, especially with, you know, the COVID health pandemic, have implemented furloughs, either a complete furlough, a shutdown for a temporary period of 4 to 6 weeks, or, you know, a reduction in force with hours, or, you know, there's a lot of creative options, you know, so that we can try to avoid, you know, a large scale layoff. Now, that leads me to the next issue that we should talk about, which is, you know, what is the reason? Why do you need this? Why do you need a RIF? This is very, very important because number one, it's going to follow you. It's going to follow you way beyond the RIF. If the RIF is challenged in court, a plaintiff will ask for discovery of the company's finances, for example, if the company says, well, I'm doing a reorganization for financial reasons. So it's important to think about what is the reason for the RIF. Try to keep that reason as narrow as possible. Try to keep the scope of the layoff as narrow as possible, because the scope of the layoff, the reason for the layoff, this is going to follow you in litigation, unfortunately, if that happens. So, it also will come up to play when we get to the Older Workers Benefit Protection Act.
So I guess,
So,
I'm sorry. No, it's okay. I'm a little bit slow on the mute button today. My apologies. What about how are we choosing our workers? And that's a question that you and I tend to have a lot of back and forth on when we work on cases together, Emily, because I'm usually coming in once litigation has been filed. So what are the thoughts and considerations in terms of choosing which workers once we've come to the point of deciding of having a RIF?
Right. And that's an excellent point, because a lot of employers like to use a RIF as a way to get rid of problem employees, right? But that is a big, big risk. You never want to use a RIF as, some employers think, well, it's easier for me to tell a problem employee, oh, I'm eliminating your job. It's easier for an employer to say that rather than face the issue head on. If you have a problem employee with performance issues, you should never use a RIF as a way to eliminate that person's employment. So when it comes to a selection process, you have to be objective. Objective criteria is the best and safest way to go. I like to say, seniority is usually what comes to mind. It's truly objective, right? Last hired is the first fired. Employees can understand that, and it makes sense to them, and it seems fair to them, right? And it also rewards older workers or workers with more tenure with the company. So there's a lower risk that older workers will then sue for age discrimination. You may want to consider another objective criteria could be eliminating your temporary workers or eliminating part-time workers. You could also, as another alternative, look at your organizational chart and look at the salaries and try to figure out, well, if we need to save money, perhaps we eliminate someone with the highest salary. That makes sense. But then remember, what's going to happen in litigation is then you're going to have to disclose everyone's salaries. So whatever choice or selection process, you need to be able to back it up. Performance selection, I told you in the beginning, don't use a RIF to get rid of problem employees, but you can use performance as a selection criteria. If you decide to use performance, my suggestion would be to use a selection form. This makes performance selection less subjective and more objective, right? You can rank your employees by performance using a numerical system where you look at performance reviews, you look at seniority, you look at disciplinary records, you look at attendance, and then every employee will get a weighted metrics, and you can use that. So on the flip side, you never ever want to look at an employee's age and use age as a selection criteria, right? That's pretty obvious. I think we can all today say, well, we're not going to just look and say we're going to lay off everyone over 50, right? That's clearly an improper selection criteria. But I think it's more, everyone knows that. But what we're going to talk about in a minute is, even if you're using an objective or a legitimate selection criteria, sometimes it can adversely impact older workers. But before we get to that, I do want to mention just real briefly the importance of selecting your decision maker. Your decision maker is going to be your witness to justify and legitimize the decisions that were taken as part of your RIF. You want to use diverse teams and diverse committees, because that will also, Matthew mentioned the use of diversity and committees. I also think that's excellent approach when it comes to a RIF. You may select decision makers. You may decide that you want to give your decision makers additional information about equal employment laws or the selection criteria, but then you're going to have your diverse team of committee, an older worker, younger workers, keep your diverse committee to review them, to review those decisions.
Is there any perfect number, Emily? Because part of this obviously is not only do we want to have a diverse decision team, but also we're concerned about who is going to be deposed, right? Who is the eventual witness? So I understand the need to have a variety of individuals, but is there a sort of perfect method to limit that in order to prevent, excessive depositions on my end?
Yeah, absolutely. So my recommendation would be, you don't want 20 people involved, right? So, you may decide, you may have your executive team, your chief executive officer, your operations officer, you may have one or two leaders of the company who are the ones that are the decision makers, or you may want to have your HR manager be your decision maker to sit down and look and do this first level review, and then have maybe a committee of one or two or three executives who are experienced with litigation, who are experienced running the company, who can then be choices. So I agree with you that there has to be a good balance because, like you said, you don't want to have to deal with 20 depositions. So let's go back. I want to talk to you about what happens when you're done with your selection. When you're done selecting employees that are going to be affected by the RIF, you're not done. Okay, you really need to take a moment, sit back, look critically at the affected employees. You want to look at their age. You want to look at carefully how close are these individuals, not only their age, but how close are they to retirement? Are they about to vest in a benefit plan? That's very important when it comes to avoiding age claims, because someone who's about to vest in a pension who gets laid off right before that date may have more motivation to challenge the RIF. You want to look at recent whistleblowers. Has anybody been involved in a workplace complaint? And is there anybody that has been on a medical leave? I'm just going to finish up this section. And I know there's a couple questions, so we're going to address them in a minute. I just want to close this with the following warning. If you conduct a RIF, I do not want to see you advertise for a job for a good period afterwards. Because think about this logically, right? You have this RIF plan. You've decided that you need to eliminate certain positions. You've laid off certain individuals. You've offered them severance. You've gone through this process. And then one of the affected employees is looking for a new job, and they come across a job advertisement from your company. That job advertisement will be used against you. And I think that a plaintiff's lawyer is going to be very interested in that job advertisement, right? Because that's going to go to the credibility and the fairness of the RIF. So I think, Lauren, I think we have a couple questions.
Before we get to the questions, Emily, let me just tie this up sort of on one concluding point, which is, it sounds like a lot of what you're talking about, though, is documentation. So, what is the importance of documenting this process? And I'm hinting a little bit at litigation again, but what is the importance of documenting this process, and what's the best way to go about it?
So you'll see on the slide, one of the topics and issues that I wanted to let you all know about is the importance of memorializing the plan in writing. And this is a working document. This is a living, breathing document. This is not a document that you prepare after you've laid everyone off. No, this is a document that you start from the very beginning. On this date, the executive team and HR, we met to decide, to figure out, to resolve a problem. Maybe we have, with the health crisis, maybe we have less customers, maybe, so every step of the way you want to add to your plan in writing. Timing is also very important. And Lauren, you'll probably agree with me, but what will happen is a great defense to litigation is if, for example, you have an older worker, perhaps who's disabled, or someone who decides to go on a leave of absence, or someone who discloses a complaint to you of age discrimination. If you have this document that shows that the decision to conduct the RIF or implement the RIF was made before that employee asked for a leave of absence, or before that employee made a complaint of harassment or discrimination, that will help to legitimize the plan. It'll also help to prevent retaliation claims.
That's true. I mean, timing as a defense attorney dealing with a discrimination claim, timing can be, sort of the best thing or the worst thing for you. So to the extent that a decision was made right after somebody made that retaliation claim, obviously there's an inference that, once somebody makes a claim and then we decide to engage in either reduction in force or a termination, that inference is that, this was related to the complaint, and then we're dealing with retaliation issues. By the same token, timing can also work in our favor. So to the extent that you have it well documented that this was a decision that was made pre, any complaints or any other issues related to termination, or anything that would give that inference of retaliation, that works to our benefit too. So that's why documenting is such an important thing.
Right. So I want to answer, we have a very kind of multi-level question here regarding.
Yes, before we go to that, Emily, because I do want to make sure that we discuss this. The subject of disparate impact on in decisions that are made in connection with this, I think this is a major issue from the standpoint of litigation. So could you please address that?
Sure. So let's go back and talk a little bit more about disparate impact. Okay. So what you're going to want to do is you're going to want to sit and you're going to want to carefully look at the employees that were selected for layoff. My suggestion would be to actually look up each employee's date of birth, write their age down. Okay. And then you're going to want to look at your chart, and you're going to do the same thing, the ages of the employees that are being retained. And you're going to look and you're going to see, are all of the affected employees over 40? Or do you have a scenario where you have some that are over 40, some that are under 40? Maybe you have, a variety, maybe someone is 60, someone who's 20. That would be ideal, right? But if you look and you do this and you realize, well, hey, all the people that I selected are 50, 65, 72, 47. My suggestion would be to go back to the drawing board, go back to your selection process and try to figure out how it happened, and go through the selection process again. Disparate impact can be unintentional, right? You may decide, well, hey, I'm going to use compensation as the selection criteria. And that's a great example because, it's pretty common, right? That, the leaders of a company, maybe has the most experience, maybe they have the most they have the highest salaries. And when you use compensation as a selection criteria, although compensation can be legitimate, it could have a disparate impact where all the selected employees are over 40. So you may decide, okay, I'm not going to use compensation as a selection criteria. Let me go back and maybe let's look at seniority, or let's try another way to do it. And again, like I said, you also want to look at some of these other, avoiding adverse action. You want to look and see, again, just to reiterate, you want to make sure that, look carefully at the individuals who are about to vest in a retirement plan, because, you can have discrimination claims in ERISA benefit plans. That's a very common type of lawsuit. You want to try to avoid adverse action that could result in retaliation claim, right? You don't want to include, you want to be careful about including an individual who just made a complaint of sexual harassment, or someone who, considers themselves to be a whistleblower. I do want to say the issue about medical leave or maternity or paternity leave, we are talking about age today, so I don't want to go down too far the rabbit hole, but the federal and state laws that talk about leave rights, they do specifically recognize that, you're not automatically, interfering with someone's leave rights because you lay them off as part of a reduction in force, but you better be very careful about the selection and look critically and carefully. Are you, one way that I like to look at it is if, okay, we have one person on our selected list who's on a medical leave. Well, we're keeping 4 other people who are currently on medical leaves. So that would make me a lot more comfortable with the balance of how the RIF is affecting individuals. Okay, so I think, oh, and one last thing before we move on, because we're kind of running out of time, and I want to make sure that we do have a minute to talk about the OWBPA, but you may want to consider recalling laid off employees. If you decide that you do need to hire someone, you may want to consider, even if you don't have a union, even if we're not getting into bumping rights, but you may want to just keep that in the back of your mind as a possibility. So I'm gonna, most employers talk about severance packages. I do want to just mention federal law does not require severance, although state law might. In New Jersey, the New Jersey mini warn, we could talk about that for days as well, but this new law that most people think will go into effect in the beginning of October will require mandatory severance for a mass layoff. So that's something you want to kind of consider. You're going to put together your severance package. And when you do start to put together your severance package, you're going to want to do a release, right? And that's where the OWBPA is going to come in. The OWBPA does require that you provide certain disclosures to older workers who are affected by the RIF. You're going to have 3 documents. Document 1 is going to be your enclosure letter. Your enclosure letter is going to provide certain information about the RIF. It's going to, and that's where your decisional unit, that's where your scope of your RIF is going to come into play. You have to disclose that as part of your disclosures, right? You're going to put in the applicable time period, right? Because if you have a RIF, you're going to have to give the employees that are affected 45 days to consider. Your third document, in addition to your enclosure letter with your notices and your release, is the decisional unit disclosure. And that goes back to what I was talking about before with your 2 columns with your adverse impact analysis. You're going to have to disclose the job titles and the ages of those that are affected by the RIF, and the job titles and the ages of those who are not affected by the RIF. Okay, so at this point, what I'd like to do is I'm going to turn it back over to Sarah, because we want to finish up and talk to you about some recent case law.
Yes, and before we go there, we have a pending question here regarding our friends in the financial services industry, but I really do feel it extends to all or all types of workplaces. And could you address that, Joelle?
Sure. So there was a question that said, in financial services, if you see an older employee being more forgetful, making more mistakes, showing agitation, how do you handle things? It says there's a lot of white paper to research when it comes to aging clients in diminished capacity, but very little guidance on detecting that in the workforce. So NASA, which is the North American Securities Administrators, actually put out a white paper on this and kind of a research report. It was last, I think, July 2020. And you can, if you want, whoever asked that question, if you want to email me after, I'm happy to send you a link to that. And we actually did a webinar entirely on this topic, which was addressing diminished capacity and cognitive impairment among financial professionals. And if you Google that or email me, I can give you the link to watch the recording of that. But look, I think the flags, and ultimately what that report said, is the flags are the same. The training that you give to your workforce about what to spot in clients is equally applicable to what they may also spot in their coworkers. And some of the trainings that we've been doing more recently focus on that and say, we're doing this specifically as to clients and as to customers, but these are the things that you also need to be on the lookout for with the people you work with. And in fact, most of the people who were made aware of this, the ways they were made aware of it was from coworkers. And typically it's going to be those that are on the team with the person who's suspected of having diminished capacity. So, I think kind of going back to this to couple this with the ADEA and to get away from this sort of age-based issue is to have protocol in place for how you investigate this, preferably written. It needs to be age neutral. So again, needs to be whether someone has it, and the Nassau report, as well as our webinar, focused on diminished capacity in general, not just for people who are older, but if someone is suffering from substance abuse, right? And they're showing up and they are under the influence of certain substances, are they having these same sort of issues, forgetting to enter orders or doing things incorrectly or being forgetful, that sort of thing. So, there's, like I said, we spent an entire webinar talking about that issue, so there's a lot to cover. But I would say you look for the same things as you would look for in customers, first and foremost. And in dealing with that, you have to have a specific process, just how you would deal with any other HR complaint about any employee, whether it's harassment, whether it's related to age, to gender, to discrimination, whatever the case may be. It still needs to operate under the same gender neutral as well, but age neutral guidelines in terms of how you're going to investigate and handle that.
Thanks, Joelle.
Right. The fact that someone is an older employee does not mean that the older employee is insulated from supervision regarding mistakes or forgetfulness or that type of thing. An older employee is going to be subject to the same standards, and this is the important part, as everyone else. So
that's excellent. That's an excellent point, because that actually is a good segue into what Lauren's going to talk about, which is what's the legitimate reason. Employees are going to be, even if they're older, they're going to be, subject to the same standards. Lauren, what kinds of things should be done to protect the company from ADEA claims?
Sure. So I guess this is the perfect segue, because actually one of the cases that we highlighted, which was the Boyle case out of the Third Circuit, talks to somewhat similar issues, because there the plaintiff who made the age discrimination claim was a doctor who was having some performance issues. And the question was whether or not that doctor was performing as the standard of care. And that essentially was the employer's legitimate business reason for the termination in that case. So I would briefly highlight that as sort of the perfect example, because there is a question as to when an employee brings an age discrimination claim and they are able to satisfy that they are a part of that protected category. Well, what is the employer's legitimate business reason? In the Boyle case, it was substandard performance, that this doctor was not performing to the standard of care. And I'm going to jump around a little bit just because we're running light on time, and I don't want to keep anyone past 1:30, but that also speaks pretty much easily to the second and third point here, which is performance reviews and really just documenting performance issues. The importance of documentation cannot be suggested enough, because when you have somebody who's either not performing to the standard of care as it relates to that doctor, or just an employee who's not performing, up to par, it's so important to document these issues, because at the end of the day, when you are facing that suit where someone is saying that you took some action according to their age, you need to be able to hold up a document, point to a decision, point to a process that happened, to essentially use that to shield your conduct. That is your legitimate business reason. And the best way to establish that can be through testimony of witnesses, but also more importantly, through documenting, particularly to the extent that you are the type of organization that frequently documents performance reviews and performance related issues. So it sort of segues perfectly into the Boyle case. I will also anecdotally say that I had a case a year or two ago that had a similar situation where the plaintiff in an age discrimination case was a doctor in an emergency surgical setting. And when there were complaints about the care that was given during an emergency C-section, that was documented. And thereafter, when she brought that age discrimination claim, we were able to point to the documentation as that legitimate business reason. So it does raise that issue of, what happens when somebody's performance is subpar? Well, age isn't the reason. It's more focused on the performance in that situation. So now moving a little bit backwards, but I guess the first thing I would say when it comes to termination issues is knowing your jurisdiction is really important, because different jurisdictions are going to have different standards. Here we know that the federal standard is a but-for standard, but a lot of state law corollaries as it relates to age have a different type of standard. And even, for instance, the New York City Human Rights Commission that applies to New York City has a very liberal standard for identifying potential discrimination. And it's not a but-for standard, it's rather a motivating factor standard. Essentially, was age one of the factors that was considered? So again, I think the first issue I would say is know your jurisdiction, because whether somebody is bringing a claim under the ADEA, which is what we're talking about, or one of those state law corollaries, that is going to be essentially the standard that you're measured up against when you're putting forth these reasons for taking the action that you did. Lastly, I just wanted to talk to this sort of ultimate conclusion here, whether the person is close to pension, retirement eligibility. This is a business related decision in a lot of ways, but it really does speak to the fact that, there might be additional considerations at play. When you're getting to the point of making decisions related to termination, you have to look at this employee based on the whole picture, because as we know, litigation and particularly discovery is expensive. So to the extent that we are going to be making decisions about termination, and somebody might be, their benefits might be affected or a pension might be affected, that might be in and of itself a reason for somebody to bring suit. And so there might be other business decisions to be made in kind of coming to that calculus about termination. Lastly, again, I don't want to keep anyone past 1:30. I did want to highlight a number of cases that have come through the last few years. Some of these cases, and I believe they are part of the materials that we circulated, but if not, we're happy to provide them. Some of these cases were decided under the federal standard, and some had to relate to a state law standard, but they do provide some interesting anecdotal guidance about what is enough, essentially, for an age discrimination claim. I briefly wanted to highlight the Jefferson case, because that's a case that, the words that as we prepared the CLE and talked about some of the words and the language that's used, Joelle and Matt pointed out the okay boomer language that I think was reported on in 2020. Justice Roberts actually asked a question during the course of oral argument at the Supreme Court about, well, is that enough? And I still don't think we have the answer on that, to be frank. But that was a case where they used the word senior and junior. That's the Jefferson case from 2014. And whether the word senior is enough to implicate that we're talking about age. And there the court found that yes, there was an insinuation that the use of the word senior related to someone's age. We've talked about this internally and roundtabled at junior, less experienced, more experienced. Joelle briefly talked about technology, highlighting whether or not somebody has certain technology advantages or knowledge. Well, if you continue to press them about, well, you don't know anything about this type of technology, it just came out. Well, those comments made over and over again might, pass that threshold of being a stray remark and cross into the category of being severe and pervasive. So I don't want to sit here and go through each and every one of these cases knowing that we're a little tight for time, but I do think that they provide some good, guidance for us in terms of what remarks are enough, what legitimate business reasons are enough, particularly that Boyle case where you had some substandard performance. And then lastly, just the importance of documenting, because if and when this gets to the point of litigation, despite all of the good advice that you heard from Joelle and from Matt and from Emily as to ways to appropriately, make decisions and document those decisions in the hopes of avoiding litigation, at the end of the day, sometimes litigation is inevitable. And when that litigation happens, you want to ensure that your process has been appropriately undertaken, but also appropriately documented so that you're hopefully able to defend that case and perhaps even get to summary judgment and get a summary judgment decision before you even put it into the hands of a jury. So that's about it on our end. I don't know if we have any additional questions. I did see that there were.
Yes, we do. Yes, we do. We have
You
a
know what? I'm
question.
gonna turn it back over to
Do
you,
you,
Sarah.
Do you anticipate a substantial increase in coming years in ADEA-related litigation, given the country's workforce demographics? Yes, that's what motivated us to do this particular webinar, which I hope you all found helpful.
I do, and I would
And-
just particularly note that I think COVID-19 is going to have an impact as well, just in terms of who's returning to the workforce and who is not. I would also briefly note that, obviously we don't know what's going to happen with legislation, but the House has now since passed twice legislation. It's made it through the House twice, and it's been shot down by the Senate twice. But that would essentially change the standard, that but-for standard under the ADEA to a motivating factor standard. So I don't know if that's necessarily going to come around in the next few cycles, but I do think that there will be an increase in litigation based on both sort of that legislation, but then also maybe perhaps some COVID-19 related issues.
And finally, in case you guys didn't look at the chat, the second CLE code is older. I'm sure no one had guessed that before I said it. I hope that you all enjoyed the seminar and that it was helpful to you and that you have a wonderful afternoon.
Thank you.
Thank you,
Thank you, everyone. Thank you.